This is what I want to say. Homie, listen. You ain't beat that case because they couldn't prove jurisdiction. It's a whole lot of niggas in feds. Say, homie, if that's the case, I done had niggas out the feds tell me that same thing. And they go to court with that feds shit, talking how you talking, and they put their ass right back in federal prison.
You said they go to court with what?
The exact same thing that you done said. They done presented that to the courts and they messed their life off. Homie, they got jurisdiction because we in the country and you done broke law in their land. Nigga, if they can go get El Chapo out of Mexico and Mexico don't extradite, say, homie, them white folks do what they want to do with us. You in LA. If you try that in Texas or down here in the South, Mississippi, Alabama, they go hang you.
Negative.
Listen, homie. Listen,
Negative.
homie. Listen, name me a nigga done beat it with that. Cause you just said they dropped the charger with no reason. So you don't have no proof that what you presented is the reason. Most niggas who take it that far as you take it.
I got it on documents. I got it on documents.
But I'm saying you got it on document that they dropped it for no reason. You don't have nothing on document that they dropped it because they didn't have jurisdiction. They never admitted they didn't have jurisdiction.
Here's the thing. Okay, well, here's the thing with that.
Okay, so look, this is what I was trying to express to the brother Charleston White before he went into an emotional frenzy. The European law and the statutes and policies under it that apply to commercial property that he was taught or that he learned when he was doing pre-law and whatnot and whatever else, that applies to commercial property. He's not referencing to common law. I'm speaking about common law, the laws of the land that apply to humans, okay? Not the 14th Amendment citizen by way of the birth certificate and the social security number. Now, what we're going to get into is jurisdiction, because that's what he was saying. He was saying that the United States has jurisdiction over us. So we're going to get into jurisdiction. Now, it's multiple types of jurisdiction. We got subject matter jurisdiction. We got personam jurisdiction. Territorial jurisdiction. Okay? But right now we focusing on subject matter jurisdiction, because subject matter jurisdiction is the jurisdiction that can be challenged at any time before, middle, or after a person has been convicted. Okay? You can always challenge subject matter jurisdiction. Now, let's get into it. Subject matter jurisdiction. Jurisdiction of subject matter means or refers to the jurisdiction or power delegated to a magistrate or judge or court to rule, to render decisions in a particular class of cases. Thus, consideration is given to the limited jurisdictional powers of the judge, the court, etc., or whether or not the judge, or whether or not defines the abstract questions surrounding the affirmations as to whether or not the court has the power to adjudge or to adjudicate in a controversy or case placed before it, based on the facts of the case. Subject matter jurisdiction, a more critical type of jurisdiction, and goes directly to the question of whether a court has the authority to even hear a matter or issue. In personam jurisdiction, subject matter jurisdiction cannot be waived by any party involved in the matter. It cannot be waived by any party involved in the matter, okay? If a court lacks subject matter jurisdiction, then the court has no authority to proceed with the case at hand, okay? If the court lacks subject matter jurisdiction, then the court has no authority to proceed with the case at hand, all right? So now, we about to get a little deeper into it. I'm getting into the meat and potatoes, and I'm going to for sure break down more stuff for y'all to get more in depth with it. But I'm giving you the meat and potatoes now just to kind of give you the kind of understanding. I want you to go check this out. I want you to go look this up. Don't take my word for it. This is not my information. This is the law of the land, the law of the people. So, everybody can get this. Okay? This ain't like just for me. I didn't make this up. This is what runs the world. Okay? So look, jurisdiction. All Moorish Americans must be aware of the fact that subject matter jurisdiction may be challenged at any time. It can be challenged before a trial, during a trial, or after a trial. And it can be challenged even if the accused party has already pled guilty and has been duly convicted and sentenced to jail or prison. This rule of right stands even if the accused is currently serving time due to a conviction. A jurisdictional challenge of this type is never limited, since it goes to the foundation of whether the court had the authority to incarcerate the person or to even try the person in the first place. The administrative court system lacks subject matter jurisdiction on all criminal charges as practiced in these days. Which means they lack it now. Okay? Anyone sentenced to jail time under an administrative court has a standing right to challenge the jurisdiction of that court. Remember these following 7 rights and rules. So we're going to give you the 7 rights and rules that you need to know. That these are things that have to be proven as part of jurisdiction. Okay? The accused party must be properly identified and identified in such a fashion and manner that there is no possibility for mistaken identity. That's number 1. Number 2, the statute of offense must be identified by its proper legal or common name. A number applied to represent the offense is insufficient, which we see that in a lot of court cases. They just give you like a penal number and no detail. All right, so that's holes and leaks in the jurisdiction already. And the accused person must be properly identified. How often is the accused person properly identified in a court case? See, a lot of people don't know these are things that have to be done during court, but getting lawyers and different other things, we give up that jurisdiction so we don't even know these things or get a chance to prove these things. But yeah, number 3, the acts of the alleged offense must be described in non-prejudicial language. That means it got to be in plain language. It must be described in non-prejudicial language and detail so as to enable a person of average intelligence to understand the nature of the charge. Bang, bingo. Understand the nature of the charge, a person of average intelligence. Now, you tell me, how often do people understand what's being written in those documents? Because they speaking in legalese. And then the information that you come across in there, you don't really understand it. So, yeah. Nature, okay. Enable a person of average intelligence it must enable a person of average intelligence to understand the nature of the charge and to enable the accused preparation of defense. So, both. That's how clear it must be. Number 4, excuse me. The accuser must be specifically named. He or she may be an officer of the court or a third party, but some positively identifiable person, a human being, it got to be a human, must accuse some certain natural person must take responsibility for making the accusation, and not an agency or an institution, a corporation, or artificial person. Now, when you typically see the paperwork on court documents, it says the person who they trying to charge, the person who they charging, and it'll say whatever the state or the county's name is. Now, is that or is that not an agency, an institution, a corporation, i.e. an artificial person? Okay? So, this stuff that you got to pay attention to, which is why they say words is powerful, and that's why they call it spelling, because we casting them out unknowingly. So, yeah, this is why these are things you got to pay attention to. And I mean, it's deeper things than this to be able to stand on your square. But I mean, it's more things to be able to stand on your square. But yeah, this is a huge part of it because they got to prove jurisdiction. So look, number 5. The accusation made against the accused must be made under penalty of perjury. If penalty of perjury cannot reach the accuser, there is no accusation. Otherwise, anyone may accuse another falsely and without risk or liability of punishment. Meaning, the person who's making the accusation, they must be able to be charged with a penalty of perjury just in case they're not telling the truth. And a corporation can't be charged with that. An agency can't be charged with that because they don't speak. They have representatives. Okay? So like, yeah, this is, man, all the holes, I'm showing you all the holes in the jurisdiction right here on why they don't have jurisdiction. Boom. Number 6. In order for the court or the accusers to comply with the 5 lawful elements as stated above, and as a condition for the accusation to be valid, the accused must be accorded due process according to the law, and the accuser must have complied with law. The accuser must have complied with law. Okay? See, that's the thing but you got to know what law is to know if they complying with it. So, we always going to get sailed up the river because we don't know what law is, so we don't know if they comply with it or not. Only thing we know is the stuff that get hyped up that people then been able to get out of jail on or get an appeal on because they made it like a big thing, but we don't really know the law. So, look. Where was I? Hold on, let me get some water. Okay. All right, I'm back. All right. And the accuser must have complied with law, proper procedure, and form in bringing the allegation or charge. See, these are things that we don't know. Number 7, let's get to it. The court must be one of competent jurisdiction, having actual judicial authorization, meaning a delegation of authority order. Go look that up. Go see what that is. A delegation of authority order. It's in the parentheses. You see it right there. Number 7. Let's get it. To have valid process, the tribunal court must be a creature of its constitution and be in accord with the law of its creation, i.e. an Article 3 judge. An Article 3 judge. Now Now go find out what an Article 3 judge, whether you got to Google it, YouTube it, however you got to get it, just go get it. An Article 3 judge. The Article 3 judges are the judges that have authority and are more in line with the Constitution, or are in line with the Constitution. All right, so look, that's Junior in the background too. Don't trip. He back there chilling. So remember, hold up. Okay, all right. So look, we just ran through the 7 rules. They up on the screen. You can pause it, check it out, Google it, screenshot it, whatever you need to do. Just get it, man. Get it so you can inform yourself and stand on your two, cause it's real liberating. It's real liberating. It is. Okay, but yeah, let me finish, and then we gonna end this video off. Cause I don't want to make this too long. It's already long. You feel me? But yeah, let's get it. All right. Now, remember the importance of the rule of identity and the significance of your impropria persona. Impropria persona, I'm going to get into that on another video. So, and I'll break that down so y'all can understand that. But, and the significance, remember the importance of the rule of identity and the significance of your impropria persona. Remember that if you hire a lawyer or an attorney to represent you, then you have given him or her your birthrights, the rights you was born with. So can't nobody take away or give you rights. You was born with these. God gave us these. These was given to us by the Creator. We run this, okay? You have given him or her your birthrights and have given jurisdiction to the court. Lawyers are officers of the court, and their obligations are first to the court and not to you. Okay? Understand that. To the court. Their obligations is to the court first, not to you. This relationship constitutes a conflict of interest. Now, that's another thing. That's a conflict of interest, which means that the court, it would be like like let's just say the charge should be null and void. But just to make it quick, the charge should be null and void. Boom. Next one. See Corpus Juris Secundum. CJS Volume 7. Section 4. Attorney and client. The attorney's first duty is to the court and the public, not to the client. And wherever the duties to his client conflict with those he owes as an officer of the court in the administrative of justice, the former must yield to the latter. Clients are so-called wards of the court in regard to their relationship with their attorneys. You ever heard the term ward of the state? When you like in a foster home or in jail. Yeah, it's all the same. Ward of the state, ward of the court. That's what we are. We gave them jurisdiction. So look. Hold on, let me get back to this. Where was we at? Okay, the attorney's first duty. We back on C Corpus Juris Secundum. The attorney's first duty is to the court and the public, not to the client. And whenever the duties to his client conflict with those he owes and Whenever the duties to his clients conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. Clients are also called wards of the court in regard to their relationship with their attorneys. Next, corpus juris secundum assumes courts will operate in lawful manner. If the accused makes this assumption, he may learn to his detriment, through experience that certain questions of law, including the question of personal jurisdiction, may never be raised and addressed, especially when the accused is represented by the bar meaning the lawyer. Sometimes licensed counsel appears to take on characteristics of a fox guarding the henhouse. Jurisdiction, once challenged, must be proven. Jurisdiction, I'm going to say it again. Jurisdiction, once challenged, is to be proven, not by the court, but by the party attempting to assert jurisdiction. The burden of proof of jurisdiction lies with the asserter. The court is only to rule on the sufficiency of the proof tendered. See McNutt versus General Motors Acceptance Corporation. Okay? And when you look it up, you can plug all the numbers in the years. But yeah, C. McNutt versus General Motors Acceptance Corporation. The origins of this doctrine of law may be found in Maxfield versus Levy also. And same with this one, you can plug in the numbers, the year, chapters, and whatnot. So yeah. Jurisdiction, it must be proven. Jurisdiction must be proven, okay? And this is all verifiable information. Especially these case laws right here. This is all verifiable info. All verifiable info. You just gotta use your brain a little bit. Plug it in, copy and paste, whatever. However you gotta do it. But you gotta get it. Well, you don't have to get it, but prove that it's wrong. Prove that it's wrong. Prove that it doesn't work. Don't be scared. No, don't be scared. But yeah, so the court is only to rule on the sufficiency of the proof tendered. The proof tender mean the court is only to rule on the sufficiency of the proof of jurisdiction that is provided by the other party that is making the accusation against the accused. Okay? So the person that's making the accusation, that's accusing whoever of doing whatever in the courtroom, trying to charge you, they have to prove jurisdiction. Like they have to like hand it over. Like it's documents that they have to hand over. Now, they can't do that. They don't have those documents because, as you can see from the few pieces of literature that I just read up above, it's leaks all in the proof of jurisdiction, which is why they can't prove it, which is why we should challenge it at all times, which is why we have the right to always challenge it. And yeah, stand on our own too and don't give in to no lawyers. So yeah. I came, I saw, I conquered, I went in there and I did that and I stood on my own too. It was more things that I needed to address. I didn't want to make the video too long because I know the attention span of the people these days can not be as long as the video. Okay? So they got us all socially engineered. Don't try. I mean, I'm a product of it too. So, but yeah, go look it up. Don't take my word for it. Go check it out. Go, you know, if you already in the situation, use the information. Go stand on your own too. Look deeper into it. Don't just take my word for it. Prove me wrong. Yeah, that's pretty much it. If I said it, then I stand on it. I want y'all to hit that like button, hit that subscribe button, share this. Yeah, you can tap in with me. You can hit me on Instagram. I_stand_on_that. I stand on that. You feel me? Same thing with YouTube. Like I said, hit that like button, hit that share button, hit that subscribe button. And yeah, tap in with your boy. You can message me. I'll send you some info, point you in the right direction and whatnot. We can chop it up, whatever. Let's get it. Let's get it. If I said it, then I stand on it.